everyone, my name is Rachita Mathur, currently working as a legal intern in LEXCLIQ. So today I will be discussing a topic on prosecutors in a criminal justice system. So today in this video I will be dealing a gist of this topic. So first of all we will look at the basics of this topic. The role of public prosecutor, as we all know, begins after the police is done with its investigation and where a charge sheet has been filed. The main function of public prosecutor is to prosecute criminals in a court of law. Further, prosecutors are the counsel for states in both civil and criminal laws in a criminal trial, and the extent of their powers may vary from country to country. The institution of prosecutors has generally been given a lesser importance in the Indian legal system. The problem of criminal justice system in India may be due to lack of judicial manpower, inefficiencies of investigating agencies of the police, and corruptions. The prosecutor receives lesser attention during being a core part of the administration of criminal justice. Faster trials, good rate of convictions are the hallmarks of a good prosecution system, and a strong prosecution system mechanism that plays a crucial part while establishing a rule of law in a society. Earlier, when there was no CRPC code, the appointment of prosecutors were that the prosecutors have to report directly to district superintendent of police. But after this code, no such function has to be done by the prosecutor. In fact, an amendment was also being made in 2005 that allows states to create a directorate of prosecution that will make all prosecutors of a particular state under the control of directorate except the Advocate General of the state. Further, the public prosecutors and additional public prosecutors are then being appointed by the state government for districts are to be selected from a panel of persons, and this panel of persons are then being prepared by the district magistrate in consultation with session judge. Now, as I have already been discussed, the main role of prosecutors in India is that the prosecution begins after the police is done with its investigation and where a charge sheet has already been filed. Now, there are various stages where prosecutor plays a crucial role, like in case of pre-trial, and second one is during trial. So in case of pre-trial, obtaining an arrest warrant that is being provided under section 70 of CRPC, further obtaining a search warrant that is being provided under section 93 of CRPC, etc. Now, during trial, a significant role of prosecutor in a trial is immense. In criminal jurisprudence, the accused is presumed to be innocent unless and until it is proven guilty, and the prosecution has to prove the guilt of an accused beyond a reasonable doubt. The trial begins after a charge sheet is being filed against the accused under section 173 clause 2 of this code, and the cognizance of offence to be taken by the court under section 190 of this code, etc. Now, certain problems is also being faced in Indian prosecution system, like the biggest problem with the prosecution system is that the Indian administration refuses to recognize the role of prosecutors as the most important for the machinery of criminal justice system. The public prosecutor is not involved in investigation. In case of Sarla vs. T.S. Velu, in this case, the Supreme Court has observed that the investigation and the prosecution are the two different aspects of criminal justice system, as the investigation lies outside the court, whereas prosecutor lies inside the court. This was the main difference. Now, the second is the flawed procedure of appointment. Here, either on a tenure basis from a penal that was being prepared by the district magistrate in connection with the session judge, or from a regular cadre of a prosecution then being maintained by the state. A tremendous workload on prosecutors. Cases are being remain pending for years at the stage of trial itself and are further prolonged through the process of appeal, which makes fighting a case in a sentence itself. Further, absence of accountability in the system. Then comes the rise of specialized crime, etc. Now, the ideal system for India that may be like system of election of prosecution must be established. Power of office of district attorney should be specified. The jurisdiction of district attorney should be specified. Further, the other measures that may be taken by them may be the salaries, the facilities that should be given as per the rules that was being created by the government. Expert in the field of information technology should be employed by the office of district attorney to that prosecution system works efficiently. Novel practice should also be implemented with the help of process of speedy trials. The National Association of District Attorneys should be made the primary body to gather the data, file reports and review working the system of district attorney, and their recommendations should be considered while preparing new legislation and bring policies in the field of criminal justice system. At the end, I want to conclude that Supreme Court has discussed the feasibility of creating an independent separate cadre of judicial magistrate for monitoring the evidence that was being collected during criminal investigation, which only indicates that it recognized the failing of the current system and there is a need for judicial guidance in the matters of the investigation by the police. The purpose will be better served by the prosecutors and the magistrate whose requirement lies on the bench and not on the field. Thank you.